This conference will now be recorded.
Adam, yes. I think you're on mute.
Oh, what? Sorry about that. You'd think after 5 months to get used to this.
Never.
So looking through the bullet point list and going back to recommendation 2013, I mean, obviously, I agree with everything that's on the list, but it's interesting. It's for the most part responsive or reaction. These are roles of reacting to things, right? Accepting things that are coming, certifying things, responding to things. There is, coordinating. For example, coordinating the compilation of the administrative record for judicial review. But it seems to me that it would be useful to have a more proactive, at least one sort of proactive item in here. And I'm not quite sure what that means, but something that really, I think, reiterating the fact that there needs to be one person here who's not just the repository for this information, collecting it all, but who's affirmatively seeking it out, or at least reminding the relevant personnel within the agency of their obligations. I mean, in a way that falls, I understand that falls into things like creating the record and coordinating. But it seems to me that having some item in there for a more sort of affirmative encouragement and role would be a good thing.
That's a great point. Lane, did you have a point as well? I think you might also be on mute.
Jeremy, could you just clarify what document we're working off here?
Certainly. So the memo was sent with yesterday's reminder email, as well as the earlier invitation email. It's also on the website. I can certainly send around access to it again if anybody needs it. It is the memo dated March 11th, entitled
that
Instruction. Yep.
That
great.
helps me at least. That helps
Great.
me.
Sorry, Lane, I see that your microphone is green, but I'm not hearing anything. Are others hearing? I think it's a no. Well, we'll try to come back to Lane. He's working on fixing it now. Did anybody else have any other points on this topic? Sort of responsibilities, or responding to Adam in terms of what it would mean for a record custodian to affirmatively seek out records or take an active role in that.
And if I could just specify what I guess, even something like identifying, notifying, and reminding relevant personnel of their obligations with respect to the administrative record.
Sure.
That's really all that I'm talking about in terms of identifying and notifying.
Yeah, so I think that that's a good point, and certainly something that should be reinforced throughout the process, just to make sure that folks are just have that in the front of their minds. Something that I think might be unique to certain agencies depending on the size. There's an item on the list of discrete tasks that pertains to, I'm trying to find it, metadata, labeling, tagging, or adding metadata to rulemaking records. At least in the case of EPA, where we have like a separate, I guess, contractor that manages like the regs.gov and the FDMS system. So for us, like that's something that our docket management team would do in terms of the metadata and tagging things and labeling things. But I understand that in smaller agencies where it's sort of like one person literally is responsible for everything, then that is something that a task that a record custodian or an administrative record custodian should do. But it's just something I guess I didn't really appreciate so much. So I thought that was really interesting and a good addition to the list.
No, that's great. And that raises a great point of, sort of what qualifications will the ideal record custodian have? And, it doesn't necessarily mean there is one record custodian. In larger agencies that do a lot more of this, you have a docket office or perhaps a custodial office. So again, guidance documents address a number of things that go to what is the characteristic and appropriate record custodian. It may include access to relevant documents, the ability to identify which documents belong on the record. It could be someone who's actively involved in the rulemaking. It could be somebody in a records management office. It has to be someone who coordinates with an OGC, for example. It may be relevant that the person handles classified or other sensitive information. What characteristics of those or others, what qualifications will the ideal record custodian have? Are there any other qualifications beyond those listed here that custodians should have, or are there any listed qualifications that are perhaps less important? I'll take that as it's a good list. So also sort of turning to Noel's point, as a general matter, should agencies locate custodians in a centralized record keeping office? Should an employee in the office developing the rule serve as a custodian? What are the pros and cons of each approach? I mean, I'm guessing this is going to differ from agency to agency or even rulemaking to rulemaking. So what factors should agencies consider when selecting between the two approaches, or say adopting a hybrid approach of having a custodian in a rulemaking office as well as in a docket office? So Noel, if I can put you on the spot. So EPA actually has a docket office that maintains a lot of these records and takes the main role in labeling, you said, maintaining the record itself. How does that work? How did EPA come to that decision? I assume it was a long time ago, so who knows? But are there any sort of pros or cons to that approach?
Yeah, so yeah, I'm not sure of exactly the history of it. I think that was way before my time, but sort of how it works is we have we have multiple, right? So we have our docketing center, which is like our reading room. I believe it's in DC, where we keep, our hard copy materials of our rulemaking records, or dockets rather. But then we also have the docket management staff. So we have the folks that sort of guard, for lack of a better word, the hard copy stuff, and then we have our folks that manage the online docket, which then often, feeds into the record eventually upon a challenge. But in terms of the record itself, we have, our guidance provides that the person that should be responsible for compiling and maintaining an administrative record is the highest career person that is responsible for oversight of the action. So at EPA headquarters, at least, that translates to like an office director. And that person would be responsible for receiving the materials, making sure that they're properly included into the record. Even though the standard for what belongs in the record is a legal one in terms of the universe of information that was considered by the decision maker, either directly or indirectly, in making the final decision, that is a legal standard. But sometimes, and oftentimes maybe, it does boil down to somewhat of policy calls, because of course the term consider is not something that is legally defined. And so often it's like, if someone just looks at something and then just determines that it's not even worthy of further sort of review, is that considered? And so, like, to the extent that those sort of like lines need to be drawn, I think it's really valuable for an administrative record custodian to be very familiar with the action, and to be very familiar with sort of the universe of information that the agency is privy to in that sort of process.
That's great. Thank you. Yeah. Any other perspectives from other agency folks on the call? So another topic is sort of selecting an appropriate record custodian. So let's see. I guess one other additional question here is some guidance documents actually address these things in depth. Others basically leave it to subcomponents to develop their own custodian policies. Is there any familiarity with either of those approaches in the call, or what are the pros and cons to actually setting an agency-wide policy versus leaving it to subcomponents to develop their own internal policies?
Well, if I can, Jeremy, this is Dan Cohen. I don't know if you can, I hope you can hear me.
Yeah, absolutely.
If you go below that, right? Because even within subcomponents, and you alluded to this in your intro to the last topic, it may be rulemaking by rulemaking in some cases, right? Just different program offices may do particular rulemaking differently depending upon how often that subcomponent actually engages in rulemaking, just in the sophistication of the people who are working on that particular rule, albeit they interact with more sophisticated people in rulemaking generally throughout the department as the rule goes along, but they may not even understand these concepts at the beginning of the process to know what to do. So it may really kind of drill down even below the level that the report, as you now have it drafted, really contemplates. It may go further.
Interesting. Yeah. No, I think that'll be a main issue as we work towards the final product here. What level of detail should these sort of agency guidance documents go into, and what should they delegate to, lower level officials or heads of lower level subcomponents that may have more familiarity with specific proceedings. Great. So unless there are other topics on sort of the responsibilities of a custodian or the characteristics or the process for selecting, I'll move on to the next topic, which is really creating and maintaining the rulemaking record. We've talked about in the past what sorts of documents go into a record and what sorts of documents are excluded. Here, we're speaking of the actual physical or electronic record. What actually is it in a very real, concrete sense? And again, agencies, I believe, have very different tools. I think in our first call, we talked about some people use Sharepoint, some use shared drives, some index things on Excel. And it sounds like there's a really wide variety there. As far as ACUS recommendations, it should be organized as a concrete thing. DOAI guidance refers to a decision file as a collection of documents in an accessible location. Others refer to a legal file. So traditionally it was referred to as a box with a bow. So in an electronic age, what is that electronic box with a bow? Yeah, certainly, some tools, it sounds like agencies use specially designed tools, others use off-the-shelf tools. Obviously a variety of factors I imagine could play into this. I list some of the ones I came up with on page 6 of the memo, but I'm interested in your thoughts. What factors should agencies consider when selecting a record-keeping tool? Are there any facts agencies should consider beyond those I've listed? Are any of the listed factors unimportant or maybe even inappropriate? Yeah, Melissa.
I'm not sure of the relevancy of the likelihood of future litigation. I guess I'm sort of thinking of the Washington Post test. How would that look on the front page of the Washington Post? And the idea that agencies should do different things based on the likelihood of future litigation. I'm just not sure that would play out well. I guess I think we should. I'm not sure that's a relevant factor.
Sure, follow the same procedures in every case.
Yeah, or at least not necessarily consider that as a reason. The idea that I think it might give the idea that we might be sloppy or offer inadequate record keeping if we don't see a high risk of litigation.
Yeah, it's a great point. Other thoughts? Noelle, did you raise your hand?
Yes. Can you see when I unmute? Sorry, that's interesting.
Yes, we can hear you. Yes.
Oh, okay, Got it. So I was like, how do you know?
I see everything.
I'm looking at this, and I guess I had a clarifying question, and maybe it also kind of doubles as a point, which is, in terms of the rulemaking record, are you referring to the administrative record or like the NARA record?
In today's meeting, just the sort of internal rulemaking record before we talk about a public rulemaking docket or an administrative record for judicial review. So really, this is just the internal record kept during the rulemaking process internally to the agency.
Okay, and I only asked. Oh.
No, please go.
Okay. I only ask because, I get the impression that they are two potentially different things in terms of like the universe of and I'm not the sort of information law / records person at my agency, but my understanding with sort of like informal conversations is that there are obligations for an agency to preserve all, like, basically, every scrap of information pertaining to a rule that has been finalized or issued or what have you, or maybe close to every scrap. And that might be a separate, although related and parallel undertaking to maintaining and compiling an administrative record for judicial review. Although the latter is potentially a lot more narrow because of the whole, only those things considered versus, for purposes of NARA, like everything,
Right.
And so that's the only reason why I asked that question. Yeah.
Yeah.
But
Matt,
again, that's sort of a philosophical question about, what do you consider? I don't mean consider it in the context of this document, but how do agencies approach that record? I mean, what are you doing with like sort of drafts and comments back and forth as you're writing the document? Are agencies maintaining that as part of the official rulemaking record or not? Because I think that different agencies are doing different things there.
Yeah, that's always sort of the elephant in the room in these conversations is what does it mean to consider something? And, lots of people can come to lots of different conclusions on that, I imagine.
Sorry, I don't even mean in the considered question there. I mean, in terms of the scope of what is the record.
Right.
Most agencies just will simply say drafts are not, some agencies will say drafts are not included because that is just not the record of the decision. That is just people going back and forth and discussing what becomes the decision. And that's not it gets into the considered question, right? But you could just cut it off initially by saying, drafts just will never be in the record. Or some agencies might keep it. And I think this goes back to, justice has gone back and forth, different agencies have looked at it different ways. It becomes very hard to define the scope of that. This portion of this actually it really comes into all of the all aspects of this report you're writing here. But it becomes a lot easier to maintain a lot of the things. You don't need a lot of fancy software if you're just keeping the final documents and not worrying about maintaining. Bill said this and Mary said that, and Joe said a third thing as you were drafting the document. It becomes much more complex in terms of what you would need to maintain all of those documents.
Right. If it's a narrow record with a small number of documents, that's a fairly easy thing to maintain. If we're talking about everything that passes someone's desk or sits in the filing cabinet, that's a very different undertaking. Matt, did you have a point?
Yeah, I'm glad that Noel mentioned NARA. That's not going to be central to this working group's deliberations, but it is something that we need to be cognizant of. And we're going to have to say something about it at some point. And I don't think there's no one from NARA who's part of the working group as I understand it. But we probably ought to just touch base with NARA at some point and explain what we're doing because I think it would be useful to have their any input that they wish to have now rather than after we've produced a draft. And NARA asks us to sort of revisit things that have already been thoroughly vetted and addressed.
Yeah, absolutely. That's a great point. I'll seek to have someone at least available for our next meeting. Great. So I guess this sort of gets to the same question, but you know, one of the sort of questions from one of our members that led to this working group in the first place is, you know, what kinds of software do agencies use? What kinds of file types, those sorts of questions? I mean, is it actually worth addressing those sorts of questions in this kind of guidance document? And if so, what kind of advice would we provide to agencies in that respect? You know, which kinds of electronic systems? Are there off-the-shelf tools that agencies use? Are there, you know, less formal or maybe more formalized tools that agencies use? I guess I could, if actually for any of the agency folks on the line, what sorts of software do your offices use? If you're privy to that information and can share it.
I can tell you what you're doing at DOE, which is it's an Excel spreadsheet, right? Which just basically tracks to what's posted on regulations.gov plus any other documents that are included in what would be the record for review. So it's pretty straightforward.
Yeah. Any others in the call? Great. I think somebody had mentioned Sharepoint, at least at one earlier meeting as well, but that's sort of a similar type of program. So basically sort of off the shelf, you know, Microsoft products. Great. So the next topic concerns what steps personnel should actually take to prepare materials for the rulemaking record after they've identified the material should be included. Sort of avoiding the consider question here, which we discussed last time, but once personnel has decided that something should be in the record, how to actually go about doing that. There was general agreement last time that guidance shouldn't necessarily provide specific instructions for including different types of records, say emails, drafts, notes, and the like. There was sort of a consensus that one legal standard would be sufficient there, and it's maybe better not to, you know, say don't include drafts, do include notes, that sort of thing. But obviously, different types of records have different characteristics. Some documents are paper, most are probably electronic. Some agencies have physical objects or, you know, physical maps or oversized materials that are not easily digitized. Some are text-based, some are audio-visual, and all those characteristics could determine the actual process for preserving them. A number of guidance documents I took a look at actually do provide sort of specific instructions for what to do with print publications. For example, you know, scan them and make them a PDF. Or just provide a citation. What to do with printed images and photographs and maps and sort of electronic text-based documents, digital images, photographs, and maps. Web pages becomes a sort of important one because the idea of link rot or reference rot, if you're relying on something you find online, it could change over time. If you don't preserve it at the time you looked at it, that information could go away in the future. Sort of digital data files, you know, whether it's an Excel spreadsheet or sort of comma separated value sheet, how to store those can be quite voluminous. Computer models and data analysis are going to be more important at some agencies than others, and those can be tricky to store. Emails, you know, what kind of information, what kind of metadata do you want to preserve with emails? Personal notes, audio-visual materials, you know, recording oral communication. There seems to be lots of instructions regarding memoranda to the file, especially regarding important oral communications, maybe especially ex parte communications. Objects, internal workflow materials. So there's lots of different things here. We discussed last time having one legal standard, but what about instructions for how to actually associate them with a record? Should agency policies provide those sorts of instructions, and at what level of detail? Any initial thoughts there? Or are there any existing practices without, with regard to how to actually preserve email? Or at this point, do you just leave it in the email system, and if you need it, it's accessible later on? Then I guess as a follow-up to that, are there specific categories that these sorts of documents should address if they should address them? Are those categories beyond those listed on, let me see, I believe it's page 7 of the memorandum, that guidance documents should address? Or some more important than others? Sure. No thoughts there? Great. So, are there best practices for preparing memoranda to the record? Or I guess conversely, is this a level of detail that these sorts of documents perhaps shouldn't get into?
I'd be a little hesitant to offer much in the way of detail on this, only because it seems it would be outdated in 6 months or 18 months. If we said, for example, save emails to PDF, I have no idea if PDF will be sort of so standard and widespread as it is now. I guess I'd be hesitant to offer anything with technological details, only because I just worry it would be outdated very soon. So.
No, that's a great point. Maybe it's better left to training, perhaps, as opposed to an actual guidance document.
Yeah, so in terms of emails, I don't know if it would be as helpful to, instruct folks to preserve their emails a certain way or not. I don't know if that's what you're getting at, Jeremy, but
yeah.
Yeah.
Yep.
Okay. So I think that there are certain, I know I keep bringing this back to NARA, and I understand that that's not, the focus of this, but I will note that there are certain record schedules and agencies follow certain protocols with respect to preserving their own emails. And so I think that those would govern, right, how employees and record custodians or whomever, those would govern how those folks preserve those emails. So I don't know that it would be super, productive to sort of put forward a guidance that instructs folks on what to do, because perhaps their agencies have different protocols for that. And, I think, as far as EPA goes, we have, I keep on forgetting the name of it. I'm going to get this wrong, but it's Capstone. Where we,
Yep.
where we preserve our emails that way. And that's sort of like an automatic thing that happens. We categorize things and they just get preserved. So there isn't really a need to like take an additional step to, for example, PDF an email and then save it in a folder or something like that. It just sort of happens in the normal course. And so that might be the case across within other agencies or not. I don't know.
Yeah, so basically, as long as you follow either NARA standards or agency internal standards, there's no initial steps really needed. That's probably sufficient for the internal rulemaking record at this point. Yeah, I think that makes sense. In terms of sort of memoranda to the record, or documenting ex parte communications, this is sort of an issue that's come up a few times with us, ex parte communications. Are there best practices for maintaining or preparing those sorts of documents? And what are they, and should these sorts of documents, should these guidance documents address them?
I will say in my experience, agencies have such differential approaches to ex parte that having, with some allowing and some, prohibiting, that it may be hard to have uniform approach with respect
Sure.
to documents like that.
Sure. So maybe the best thing we could say here is just, training on those points. I think, I don't know, Peter, Constantine, if you're on the line, I think we talked about this briefly a while back, the sort of importance of training on ex parte communications and memoranda to the record. So again, maybe it's better left to training or just a general citation to whatever the legal standard is in the CFR. Great. So the sort of next topic I have is, after rulemaking personnel prepare materials for inclusion in a rulemaking record, the actual steps to add them to the record. Whether individuals add them themselves or send it to a custodian who sort of manages and organizes the record. It sounds like with some of these documents, there is no actual centralized organization. It's just maintained in an email system and it can be accessed as needed or maintained on a sort of working drive. It can be accessed as needed. But are there best practices with respect to the process by which agency personnel submit rulemaking records to a record custodian? Should agencies adopt systems which allow rulemaking personnel to independently add materials to the rulemaking record? What factors should agencies consider when they develop a process for submitted rulemaking materials? So I guess, Dan, actually, if I can turn to you, you mentioned sort of Excel spreadsheet. Would individuals go in and add things themselves, or is it maintained by a single individual?
It's a single individual, well, two individuals.
Sure.
Actually. Yeah.
Do others have? Sorry, go ahead.
They are not technical or legal at all. They are administrative. So they are putting into the documents what they're told to. They're not exercising any independent judgment to decide what should be in the spreadsheet or not. They're just maintaining it in a well organized and easily accessible manner.
Any other thoughts or experiences from other agency folks? Great. So the next topic is sort of labeling, organizing, and indexing rulemaking record materials. So ACUS on this point has basically recommended that everything is sort of kept in an organized manner. That could include labeling. Things are frequently labeled and these sorts of things. Are there best practices for how to label rulemaking materials, or what metadata should agencies consider associating with rulemaking materials? Obviously the document itself could be important, but who prepared it, who sent it, who received it, the data was transmitted, all of that information could be important as well. What sort of metadata should be captured with documents, and how should that be preserved?
So I don't know if this counts as metadata, but in a litigation that I was involved in, and again, I preface this by saying my office, we don't handle a whole lot of litigation. I just had the pleasure of being part of the couple that we did handle. And in that experience, we worked with DOJ, and they used bait stamping to organize the documents that comprise the record. So when we put our index together, it was really easy to do. It was just like a Word document. We had like a chart, a graph. No, none of those things. A table where we had the Bates number and then like a brief description of the document, which included if there was relevant dates, like if it was correspondence, we would say email from Bob to Jan on X date regarding whatever, right? And so we would link that with the Bates number. So it was very easy to track the document. So I don't know if like a Bates number would be considered metadata, but that is like a data point that I think, is really helpful to have when you're putting the record together, just for ease of reference.
Yeah, absolutely. It's sort of information that, at the time, but can get lost very, very easily at a time. Adam, I saw you nodding your head. Did you have additional thoughts on that?
No, I was just nodding my head in agreement. I think the bait stamping number is a great idea.
Great, love it in. And that's sort of doc type, sender, recipient, and date, you said. Great. I guess sort of leading into that, how necessary is it for agencies to sort of maintain very organized rulemaking records throughout the rulemaking process? Or is it something you sort of collect documents and, or, you know, make it very organized and a neat box with a bow as needed?
So not to take up too much air, but
No, please.
so I think it's really important to be as organized as possible, because you know the administrative record at the end of the day is what's going to tell the court in the event of a challenge. It's going to give the court a picture of the problems that the agency identified and the solutions that the agency constructed to deal with those problems. And the court is then, based upon this universe, is going to decide whether the ultimate decision was reasonable or not. And then that decision in turn, determines the fate of whatever the decision is. And so I think it is really important to be as organized as possible, because if the court can't even follow sort of the narrative, right, and the justification that's being provided, then you're, kind of, it will undermine your ability to argue the reasonableness of what you did, just like from a practical standpoint. Of course, that can be difficult because if you have, like EPA has rulemakings that sometimes we have records that are thousands of pages long. And so, of course, that can be difficult to sort of make sure that things are together. But I think that's, as much as possible and as much as feasible, it's important to still maintain that organization, for your sake and for the court's sake.
Yeah, and so for the internal rulemaking record, in this case, it's, if you have to prepare a record for judicial review later on, at least it's organized in the first instance. It's easier to prepare if the need arises. Yeah.
Exactly, that prospective looking, for sure.
Exactly.
I would second that, and I'd also point out, I mentioned that we have these two people who are the keepers of those Excel spreadsheets. They're doing it throughout the rulemaking process. It's not like they're going back at the end of the process and trying to gather documents and whatnot. And they're very organized and very meticulous in maintaining all of those documents. I think that's key. You really need people who are really detail oriented and are part of the process along the way. You can't just hand somebody just a mess and say, go figure this out and gather all the relevant documents.
Yeah, I guess if I could ask both of you, are those procedures sort of, and I say codified, but in a very informal sense of, even if it's just a training manual or something like that, or is it really just institutional knowledge that's passed from, staff member to staff member?
It is definitely not written down anywhere. I mean, in many ways, it may just maybe sort of be like personality, right? The people who are doing that are people who are very, like I say, they're detail oriented. They're people who like to be organized. This is the right kind of person.
Yeah, that's an important qualification, right?
Yeah, I think it's a combination of all of the above. There certainly is institutional knowledge. We have some folks at EPA who have they've been a part of so many rulemakings. At this point, it's just sort of what they do. It's like muscle memory for them, and they're very good at it. And so they, of course, share that with others, and people kind of share war stories and practical experiences and things like that. But part of it also might be written down. I know that we have, apart from our sort of general administrative records guidance, which I think could be informative and if not analogous to sort of the process of maintaining just a general rulemaking record. We also have certain programs might have their own sort of internal guidance or memoranda that outline sort of the process and the best practices. So it does vary though, and I think ultimately it's a combination of institutional knowledge, sort of informal brainstorming, sort of round tabling, as well as things that might be written down. And lesser or greater detail depending on who you ask and depending on where you look. So
Yeah, so I'll follow that up. I guess for agency folks, should it be memorialized in some form? And for non-agency folks, is there some benefit in having it memorialized and sort of made transparent?
I think it would be better to have it memorialized. I think as much because of agency turnover, I think as much as you can make a process sort of independent of the people who do it, such that when they leave, the process does not die and leave with them. I think that would be helpful. And it sort of related to that, I absolutely agree that a record should be maintained ongoing as opposed to putting it together at the tail end of the rulemaking for the same reason that personnel may have left. And as much as you can make a record, also a record independent of the people who worked on it, I think that would be helpful for the agency. We have someone in my office who's been there for 35 years, and she is great at filling in gaps in everything. But eventually she'll retire, and those gaps will exist. But as much as we can not have those gaps, I think, and create a process that does not leave those gaps, I think that would be best for agencies.
Yeah, it's a great way to put it. Make a process independent of the people who work on it. That's great. Any thoughts from non-agency folks on the benefit of the public to actually have access to these sorts of procedures? If they're memorialized in a public guidance document, as ACUS has sort of recommended. Great.
I would say there is an advantage to making these things public because, in a way, one of the things I've been thinking about and reading through the memos and listening to the conversation is that so much of the agency's work is either facilitated or made more difficult by the materials they receive from the public. And to the extent that the agency is not just sort of codifying this within its own four walls, but putting it into its own, guidance and making it clear to the public, and maybe even finding ways in the rulemaking process to encourage the public to tailor their own submissions in a way to facilitate the record keeping that we're talking about here. I think that's all a good thing. And so to that extent, I agree with everything that was just said a moment ago about the importance of getting this in clear public guidance.
Yeah, and just to add on to that, so much of the case law in this area is based on a presumption of regularity, and in some ways this is a way of actually showing your work in terms of that regularity or making it clear that there is regularity. So I see we have about 10 minutes left on this call. The last topic I have is sort of issues related to closing or preserving the rulemaking record. We sort of discussed the temporal aspect of the rulemaking record closes when the secretary signs the final document or it becomes effective or what have you. But what actual steps should a custodian take, or does a custodian need to take to close a rulemaking record to prevent new documents maybe from coming into the record? And what are these steps to preserve the rulemaking record, I guess, in the long term, but also really in the period when litigation is most likely? Or again, are sort of narrow standards in the existing agency standards sufficient to cover these topics?
I think they probably are. The agency would be kind of foolish to start getting rid of documents if they're still in a position where they would potentially be subject to judicial review on the rule, right?
Right.
Can't imagine anybody's doing that. I mean, on the other hand, agencies are probably following whatever document retention policies were put in place through NARA obligations. So, I think that's probably perfectly sufficient. Plus, these days, most agencies are using regulations.gov for the vast majority of that material. It just sits there anyway. And regulations.gov is not eliminating the docket, at least as far as I'm aware.
Yeah, there's been a huge shift to obviously electronic record keeping in the last decade and a half since some of these documents have been prepared. I mean, in the past, when you had things in a physical box, actually storing it in a specific way might have been important, but now if it's stored electronically, it's easily accessible whenever it's needed in case of litigation. So maybe these points are actually less important to cover in documents now that we're mostly electronic. Noel, did you raise your hand?
Oh, no, sorry, I was swatting a fly, a fruit fly.
Uh-oh. Great. So I see we have a few minutes left. That's all I have today. But before we end today's meeting, does anybody have any other topics related to the mechanics of compiling a internal rulemaking record during the rulemaking process that agencies should consider or should consider addressing in their policies on compiling administrative records? Or is there anything else anybody would like to raise or address?
I would just reiterate what I think folks have been saying already, which is just the importance of doing everything with an eye to the looking forward. That's just really important in terms of just making sure that things are very organized and that no one is really caught off guard in the event that something is challenged and then they're scrambling on the back end to try to put together something from the rulemaking record. So just sort of maintaining the rulemaking record with an eye towards the administrative record and beyond, and the docket as well, which is also out of the scope of this group, but still kind of related in the same process.
Yeah, absolutely. We'll discuss that next time, actually. But yeah, no, I mean, so it sounds like, especially today with electronic record keeping, a lot of the specifics of actually maintaining an internal rulemaking record are not necessarily that important. It's kind of like right-hand driving, left-hand driving, just pick one and go with it. But as long as it is organized with an eye towards the potential for a future need for this record, that's the most important thing. Great. Well, I thank you all. If there are no additional thoughts, I will, class dismissed. But I will prepare a memo for next time. Next time we'll move on to the public rulemaking docket, and I am hoping to plan something for about late August. And I look forward to speaking with you all then. Thank you.
Thank you very much, everyone.
Thanks. This is a great memo, Jeremy. Thank you very much.
Thanks.
Thanks.
Thanks, Jeremy. Very well done.